Hello and welcome to another program of Law and Order on a Friday evening. This week we are going to touch upon another very important area. As you can see around Colombo, it seems to be the answer for housing is apartments. You see the high-rise buildings going from 30 floors to 50 floors to now I think the standard is like 50 floors. But how do you own a property which is above earth, which is not fixed to earth? Do you really have ownership on that? Is the condominium law or the apartment ownership law proper in Sri Lanka, and what are the things as a layman, as an ordinary person, we should know on this? Because of the dirt, the lack of space in cities all across the globe, people are building apartments, and we need to see how legally these can be owned and what are the problems we come when it comes to ownership of condominiums. To deal with all these areas in a topic that we haven't touched before at all, I have got an expert lawyer to give you the impetus and the inputs on this. My guest today, therefore, is none other than Senaka Diseram, a practitioner in most of the areas of law and a specialist in apartment ownership law and law relating to condominium, among his other things. I didn't want to give you a full CV. And welcome to Law and Order, Senaka. How are you doing today?
Yes, I must first thank you for the invitation. I'm doing fine.
Yes.
Hopefully, we'll be able to get through a lot of topics that you can ask me with regard to this subject, which is a new area.
Yes. Like I said in my introduction, this is an area which we haven't touched before. But this is an area there are a lot of questions. Because as you see, when you look at Colombo, the amount of housing, and the answer seems to be simply apartments, because there isn't any land, especially we being island. If you look at countries like Singapore, there aren't any lands owned at all. But to start with this, I think the legal term is condominium law or apartment or law related to apartment ownership. What is the basic law applicable for these apartments?
Yes, thank you. Now, for me to explain that, we must understand why these laws came into being.
Right.
Because earlier, it was a situation where the law of the land was any property that is owned by somebody. He owns what is on top of that land.
Yes.
For example, to put it simply, if I own a 10 perch land which is worth 100,000 rupees, and you put up a building worth 30 million rupees on that, I still own that building. That was the law of the land, because anything on the land belongs to the person who owns the land. That is the basic concept of property. So because this had to be done away with, statutes came about, and one such statute was the apartment ownership law in Sri Lanka. So that made it possible for us to erect a building, break the building into units, and for each person to own their separate unit. So to come back to your question, we have the apartment ownership law, then we have the condominium management authority law, and we have the basic municipal laws. So between the three, you will be governed and with regard to your ownership of your apartment.
Right. Now, what is an apartment and how is it recognized in the context of Sri Lankan law? I mean, what do we call an apartment? Is it just any part of a house, or does it have to be in a part of a big building? How does our law recognize it?
That's a very interesting question, because most of the people think that apartment is something that is physically there. So earlier, the law that was there in Sri Lanka previously, that was the concept. But that created a problem. For example, if a developer comes and wants to do pre-sales, you know what, now these developers are putting up apartments, and even before they lay the foundation stone, they have sold most of the apartments. Yeah. So the law recognized a thing called a provisional condominium unit.
Right.
That is, it's a condominium which is recognized on a paper. So you have a plan, and you have a deed, and it's called a provisional condominium. Then you have another concept called a semi-condominium property. That is a partly constructed unit. We are familiar with that. We see partly completed things. Then we have the final one, which everybody is familiar with, that is the condominium property. That is a fully completed unit. So the advancement in the law with regard to provisional condominium units is the concept that brought about a boom, where developers can come and sell a unit that is only on paper. So there are three concepts, and each of these concepts you have to register the plans and deeds, and then they are recognized separately as a unit.
Right. Now, people talk about these common elements in an apartment complex. What are these common elements? I mean, who manages this? Who has to pay for this? And how does it work?
Yes. Now, as you know, we are talking of a building with apartments. So you will own your own apartment, and you have corridors, you have swimming pools, you have a gym, you have security, you have garbage, disposal units. So all these things are common to everybody. So the Act, the the apartment ownership law, has a definition of what common elements are. But if you were to go and buy an apartment, I think the first thing you will have to check is what common elements are described in your own apartment complex. And for that, you will have to check the condominium plan and the condominium deed. So that will tell you what are the common elements, what will be yours to own absolutely, and what is assigned from the common elements to your apartment. For example, there are things which are held in common, but you will have absolute right on it purely because it is assigned to your apartment. For example, your car park. For some, you will see when you go to buy your apartment, you will be given a definite car parking slot. So that is on your deed.
Right.
So that is, in terms of the Act, a common element, but assigned to you through the deed to your relevant apartment. So common elements are what I told, basically the things that are held in common. The Act defines it as the columns, the corridors, and all these things that are held in common. The definition is there. But if you are going to buy an apartment, it's prudent for you to check what the common elements are there in your deed, so that you will sometimes think that these are owned to you, but in fact it is not.
Yeah, so by law, can a developer, we'll say, have 30 floors and we'll say 120 apartments, doesn't he have a duty to give all common elements to everybody? Because I only understood about the car park.
Yes. Now,
or is there a way he can discriminate?
No. The common elements are generally owned by all according to the proportion given.
Yeah.
But if your condominium plan or condominium deed assigns some portion of this common element to some unit, then that will not form part of the common elements. So that is why I told you, Chanaka, it's important when you go to buy these things that you check what is in the common element, what is given to you, so that you won't have a confusion as to what forms a common element and what common elements that are assigned to other people.
Right. Now, like you mentioned about pre-sales, most of it has been a culture, I think, I don't know whether it's worldwide, to pre-sale the plan or whatever and ask people to pay in steps. And generally we come into a sales agreement when we pay the money, right? Now, at what point do you really own your apartment? That is it at the pre-sale when you pay the amount, or when you, like I'm asking when I explain my question is that when you pay, can they later, after having you pay, return the money and say, yeah, now we don't want to give it to you, something like that? Or do you really earn it at that, well, like in a deed, you really own it at the very outset when you pay the installment?
Yeah, to explain that, Chanaka, it's a very good question. As I told you, these condominium units are all in one building.
Yeah.
So there has to be a triggering point where these units that are fixed to the land will free itself from the property and are legally recognized units to be sold as separate properties. So if you look at section 7 and section 9 of the apartment ownership law, it specifically states at what point of time that breakage takes place. So with the registration of the condominium deed and the condominium plan, this property that was held and owned by the owner of the land breaks into several units. So then thereafter they are entitled to sell. As I told you, when it comes to provisional condominiums, this building does not exist. It's only in a plan. So with the registration of the provisional condominium deed and plan, then they are entitled to dispose of this as a unit. But from the buyer's point of view, you do not get title to these apartments until it's transferred through a deed. So that is why these people, they enter into sales agreements. So initially when you go, the developer will sign with you a sales agreement and say, this is your unit, and once it's completed, I will transfer it. So there are two documents involved. One is the sales agreement, and then subsequently they will issue you a deed for your apartment, and at that point of time, you will own the apartment. But you have rights onto the unit that they are building through the agreement of sale.
Generally, what is the nature of agreement to sell on this? Is it like something that the developer, like I said, change his mind and return the money to you, and you will have no other recourse than to take the money?
The developer will generally not try to do that because his reputation will be at stake. But if he does that, there are situations where that has happened, where they have planned for 9 floors, they have built 10 floors, and they have done certain things without the people knowing. So then in that situation, you have no recourse but to put your agreement to sale to suit and make sure you get the rights that are stated in there.
Now, what are the statutes that govern one's apartment? What are the law?
Mainly it's the apartment ownership law, as I told you. So that gives you how the apartment ownership will devolve to you, and also it creates a thing called the management corporation. So moment you register a condominium plan, there is a thing called a management corporation which is incorporated by itself. If you look at section 20B of the Act, it's like a company. It has its own legal basis. It can sue and be sued on its own behalf. So that is created to manage these common elements. But this does not mean that the management corporation owns the common elements. The ownership vests with all the owners. They are only like a trustee, if I say, managing and controlling, but they have wide powers. And there is a council. So the owners will get together and elect a council. And they will act like a board. But it has a separate legal entity. So that act provides for these entities to control and manage the apartment building through the management corporation.
Now, what is the difference of this management corporation? Not the difference, I might rephrase that question. This management corporation. Then there is a condominium management authority. Now, what are the powers that condominium management authority, and what are their functions with regard to apartments and complexes?
The condominium management authority is incorporated under section 2 of that act, Condominium Management Authority Act, and it is basically run by a board. And the minister in the charge of that subject will appoint that board. It has a chairman and so on and so forth. It is a more nationalistic organization. It will look into the problems of all condominium properties, not only private ones. It deals with even the ones that are there in the state. As you know, prior to these condominiums coming up, most of these flats were done by the government. So it has jurisdiction over those as well. So any building which can be divided up into units and which is livable, they have jurisdiction over. You can complain to them if your management corporation is not functioning well, or your personal situations, you can complain to them. They have jurisdiction to inquire into these things.
But you do have appeal beyond the jurisdiction also?
Yes. If the condominium management authority makes a decision, then you have to go to the writ court, that is the court of appeal, and get it quashed. But it's important, if you are before the condominium management authority, that you place your case with all the relevant evidence and documentation. Otherwise, they may make a decision sometimes which is not in line with the documents and the law. So that is up to the task of the person who is conducting the inquiry there and the people who present the case before him. It has happened in my experience.
Now, when you say condominium, I have heard in other countries, it's not necessarily the high-rise building. It can be a community of house. Is it the same in Sri Lanka, or this apartment, what I'm saying is, can you take a part of a house and say that this is coming under the apartment ownership law, or is that goes in the general laws of ownership of property?
No, Shanaka. Now, if it's a house with 2 or 3 levels or floors, that will never form a condominium property unless you register these deeds. That is where the myth is. Now, you see situations where the father lives in a 2-story house, and he gives the bottom floor to the one child, and he gives another floor to the other child. But if it comes to a legal battle, the person who owns the land ultimately owns the entire building. So those sort of properties will not automatically become a condominium property.
So can a house which has, like you said, 4 areas, big house, built in 2-3 units, as you know, in the olden days, houses were built in 2 units, sometimes 3 units. Do they fall under condominium law? Can they be brought under that?
They will not fall under condominium law, but they can be. So for that, you will have to make an application to the condominium management authority and say, this is what we have, these are the common elements, and they will take a decision whether these separate units, is it a livable situation with the common element. And then they will advise you, this is how you have to break it up, and they will advise you to do a condominium plan and a deed, and separate the single property into the units that you want. So till you do that plan and the deed, the person who owns the property owns the house as well.
What are the day-to-day rules that one should know and abide by when you're living in a condominium property or an apartment?
Yes, that's a very good question, Shanaka, because a lot of people, they just go in and buy an apartment. And then they realize what the rules are, which is sometimes not too great. I mean, if you're a dog lover or a pet lover, you buy an apartment sometimes maybe for a big price. It
actually happened to a friend of mine, and you have to give the pets to adoption.
Yes, that's correct. And then you come to the apartment and find out that, look here, you can't have your pet. So things like that. So to answer your question, the condominium management authority does not have any jurisdiction over that issue. It is the management corporation. As I said, the management corporation runs and governs your building. So there is a constitution which governs the management corporation. If you look at the first schedule of the act, that sets out the rules and regulations of how they should run their affairs. That is the management corporation. The answer to your question lies in the second schedule to the act. That gives out the rules and regulations as to how people should behave in those apartments. Because this is basically for good living. I mean, if you are making a nuisance in one unit, there are people, you must understand, there are people living above you, there are people living under you, and on the two sides, other than where the corridor and the window is. So if someone is creating a nuisance, it's going to be a problem. So if you look at the second schedule of that act, it gives out some requirements that those activities cannot be done. You can't bring substances that are like smelling, you can't have pets, you can't bring dangerous items, you can't remove walls. So those sort of rules are there. And the interesting thing is, even if all the members get together, all the owners get together, you can't change those rules. So those are ingrained rules which can't be changed.
So how about the sound pollution level? Is the general law of sound pollution applies, or is it special?
Yeah, the general law will apply, but there is no regulation with regard to sound in the act. So that is up to, so if somebody has a problem with sound frequently, you will have to complain to the management corporation.
That's not example if somebody wants to have a party in an apartment with the consent of the rest of the people, they can.
Yes, and generally these places have an area dedicated for that. So then you inform the management corporation and you have it there. The issue is if somebody is becoming a nuisance, then it's the problem. So the management corporation will have to act on that behalf.
Now, somebody who is listening to all that want to buy a condominium, we'll say one of yours. Despite knowing all that, you mentioned in different areas what are the rights and what are the liabilities. What is a checklist one should go through before buying a condominium?
First thing, Chanaka, I think people should understand we are a society generally who have been living in houses, and now what is happening is people are moving from houses to condominiums. So you must have that mindset. Otherwise, people think that the way you lived in the house, you can live in the apartment, which you can't.
You can't,
You can't. So then they find themselves in a restricted space and restricted area. So the mindset must change. Then also the main thing is you must know your developer, because you're giving money upfront. Sri Lanka does not have a system where the developer has to register. So that is a serious drawback. So unless the developer is known, you are putting most of your money into this developer, and you don't know where you stand if you don't have any credentials with regard to the developer. Then you must make sure what the agreement to sell has. The first document you will be faced with will be the agreement to sell. So you must make sure your rights are there. Also, you must have a look at the condominium plan. What is your apartment? What are you getting? What are the common elements? What are the things that you are not getting? That is the main thing. Another thing that you have to check is mortgages, because most of these properties are mortgaged, and that money is used to put up the properties. And sometimes you are not disclosed about these mortgages. So the mortgage is taken on the main land, not on your unit, and it continues. There's a section in the Act which says that they have rights over the mortgage irrespective of what happens.
Yeah.
So generally what we promote is, Chanaka, is that once the complex comes up, you do away with the original mortgage and you have separate mortgages for each unit. Then people are not reluctant to purchase, because the moment you pay the money to the developer, the mortgage is discharged and you have absolute right over the apartment. And the other one is, what does this management authority do with the complex? As I told you, they have a constitution of how you should live. That might be restrictive to you.
Yeah, and you might not like that.
You may not like that.
Yes.
The other one is, when you are buying an apartment, if you are buying an apartment which is already put up through another person, you may want to know how much of money he is in arrears with regard to water, electricity, management corporation fees. Now this third element I am talking, management corporation fees, is not known to a person who is living in a house. You and I will not pay another person for maintaining our garden and things like that. But when you are living in an apartment, you have to pay management corporation fees. That is a thing that people sometimes don't consider. And sometimes when the person sells his apartment, he has arrears of management corporation fees, which he does not disclose to you. So fortunately, from the legal point of view, there is a section, if you write to the management corporation as a potential buyer, they are duty bound to provide you the details with regard to the arrears. And sometimes you may be paying a lot of money to buy the apartment, and you may have to pay his arrears of management corporation fees, because if you don't pay, they are not going to provide you the services. And that is also a problem. Lastly, I would like to say, Janaka, that you must also know who your neighbors are. Because if you go into an apartment complex where people are not willing to pay management corporation fees,
but can they do that?
Some do it. So then the management corporation is fixed with a situation where they have to go behind them.
Right.
Ultimately, they cannot maintain the complex. Then sometimes you may see, when you go on the road, some complexes are now looking quite shabby.
Yes.
Then what happens to your property that you buy? You buy it for a certain sum. Yeah. People don't want to come.
What is the recourse then when some people are not paying? Are they bound to pay?
They are bound to pay. The management corporation has powers in terms of the Act to take action. They can, in fact, cease providing you with the common services. They can go to court. They can do these things. But the bottom line is, all this is going to create a drain on the management corporation, and the complex is not going to be maintained well. And in the end, your property price is going to come down, because nobody will want to come and live in a complex which is almost coming down in shambles. Right. So those are the things that you'll have to check.
Yeah, like in the beginning I mentioned, we are going ahead with large-scale developments on so many different types of condominium properties. And if you or I want to buy, we have so many choices as well, right? So it seems the order of the day is not necessarily a house now. We'll have to change, like you said, the mindset and go to a condominium property. But in all these laws you mentioned one lacuna, that is developers don't have to register. What are the other areas of law relating to apartment ownership law that you would like to be either changed or introduced for a healthy regime of condominium properties?
I think the main thing is the apartment ownership law requires to be amended in certain ways. As I told you, these people require to be registered. I mean, I am not pointing the finger at these developers who have done well. They have a reputation to maintain. But there are people, I mean, throughout my experience, I can say, where they have deserted the site. Then what happens ultimately is, you have paid money to them, you don't know where they are, they have mortgaged the property is taken over by a bank, and you are left high and dry. So to avoid situations like that, registration process is good. In some countries, there is a thing called an escrow account, where all the monies are deposited in escrow, and it's monitored by the authorities, so that funds are paid basically if some development takes place. Then another area I think is when it comes to mixed development. Now Sri Lanka is developing not only condominiums. You will see a hotel, and behind hotel on one side, apartments on another side. Our law does not provide for that. Either it's a hotel, either it's an apartment. So there is a thing called mixed development in other countries which is recognized, and we should be able to incorporate that also into this act. Also, Chanaka, there is a issue with regard to how the builder warranties are given. I think it should be brought into that.
The structural guarantee is
Structural
not there.
guarantee.
As you could see, a
Yes.
recent collapse of a building.
Correct.
Did not have those things.
Did not have
Yes.
those. I think those things should be brought in. I mean, why can't they put in a basic period? I mean, if you are putting up these structures, I'm sure the constructor or the person who is doing it can give a guarantee for a few years at least. We don't have you on that. Then also how the developer transfers the whole complex to the owners. I'm sure you also have had experience. I've seen you appearing in some cases where developers have like handed over the property to the occupiers in an ad hoc manner. And then we have an issue on that. Who pays for what during the transitional period? So I think those issues require to be adhered to.
Senaka Diseram, thank you very much for joining Law and Order today and for those very insightful thoughts. It's an area that is very relevant to the present context of the society in Colombo and Sri Lanka. And thank you for joining Law
Thank
and
you,
Order.
John.
Thank you. That's Law and Order for you today. We'll join you next week with another episode on Law and Order. You can join our conversation on our Facebook website. That's Facebook/Law and Order Channel I, Facebook/Law and Order Channel I, and you can post your comments and your thoughts and your messages for us to improve this program, and we'll surely have a look at them and take them into consideration. Have a good night and a good weekend. See you next week.